Sometimes things happen in an escrow transaction that will lead you to say, "What were you thinking?" This is one of those instances, and it involved a dead person, a contract, and an electronic signature. Now, an electronic signature, a brief description, is a digital version of a person's handwritten signature, and it carries the same weight and legal authority as the hand signature. So here is another story straight from the trenches of frontline escrow warfare. The property that was in escrow was owned by a client under a trust. The trust had two trustees. Trustee A had passed away, and now the trust was being handled by Trustee B, the surviving trustee, along with Trustee C, a successor trustee. The property being sold had a PACE loan on it for the payment of solar panels. The buyer wanted to continue with the payments on this loan, and so the real estate agents worked directly with the PACE lender for the assumption of this loan by the buyer. A copy of the lease assumption contract was given to the buyer for signature, and then it was given to the escrow officer so that the sellers could sign and satisfy that particular condition. A simple, standard real estate transaction, right? But wait, the escrow officer noticed that the seller's signature block on that assumption agreement said seller trust by Trustee A. Now, Trustee A had passed away about 6 years ago, and it looked like the PACE lender was never informed. So immediately, the escrow officer attempted to contact the PACE lender by email to correct this and sent them a copy of Trustee A's death certificate. The seller's signature block, she said, should show as seller trust by Trustee B and Trustee C. Okay, so here's a supposition on our part. This transaction took place during the pandemic. So we know that many people were working at home and maybe monitoring their kids' Zoom schooling at the same time that they were trying to do office work. All that could be said was that it took weeks for the PACE lender to get back with the modifications of this agreement. Meanwhile, the transaction was sliding fast into home base and needed to close escrow soon. So the modified assumption agreement and signatures were handled by the real estate agents outside of escrow. And by the time escrow reviewed the fully executed and modified agreement, they did a double take. The seller trust signature block never got recorded, despite repeated emails to the PACE lender by the escrow officer. And it was signed electronically by Trustee A. What happened here? What do they teach us at escrow school from day one? When a document is signed by a person and the person dies before that document can be used for its purpose, then the document becomes void. It must be re-signed by whoever succeeds that person in interest. In this case, Trustee A was dead 6 years ago, but someone signed his name electronically. How valid can this document be? So the PACE lender was told immediately that the seller's signature on their document could not be deemed valid. Did the PACE lender respond? No, not at all. No idea if they even got the previous communications from the escrow officer about the seller trust changes. So what could be done? The transaction was set to close. Both real estate agents felt that escrow was holding up the transaction for no good reason and begged to leave the signed assignment form as it was and close the escrow. So the escrow proceeded to explain the facts of life to them as it pertained to this transaction. Number one, a document signed by a dead person is not valid if it was not used before he died. Number two, a document signed by a live person for a dead person, whether it's electronically or by hand, is something like fraud or forgery. What if some problem came up in the future on this loan and the parties look at this document? Do they have a valid document? Because if they don't, who will they put the liability on? and, heaven forbid, seek compensation for those problems or issues? The escrow, the buyer, the seller, the real estate agent, the PACE lender, all of the above? Will the attorneys have a field day if they know that everyone was complicit in committing fraud or forgery? So the escrow officer was very persuasive in her arguments, and to protect everyone's interest, made the real estate agent go back to the two sellers who were alive, trustee B and trustee C, and had them hand sign next to the electronic signature of dead trustee A. Then she allowed the escrow to close. What are we trying to learn here? First, don't say dead men don't tell tales. That is not true in this case. Dead is dead, guys, and dead men cannot sign anything, and no one should be signing anything for them either. Secondly, watch out. Who is signing on those electronic signature platforms? Is it really the client, or is somebody else signing for the client? After all, anyone could be clicking on the computer or smartphone. Does the real client even know who is signing what for them? If a problem arises in the future, attorneys can go through the signature metadata on that platform to figure out who is liable, and you do not want it to be you. Number 3, is the closing so important that we are willing to overlook anything even when told that something is not right? Again, do you want a file that can come back and haunt you? Because I bet that is something that a dead man can do. For a couple of weeks, it was touch and go. There was anger, there was frustration, there was stress. When the escrow officer refused to close until the right thing was done so that everyone would be protected from future liabilities. This story is crazy and stressful enough that it qualifies under the annals of stories from the escrow trenches, wouldn't you say? This is Juliana too. Thank you for listening. It would be great if you would subscribe to my channel and like my videos. Until the next video, here's my information, just in case you need me. Thank you.